Here's one for you with no political overtones or implications.
Yeah, right.
I know, right? Can a state, let's just say South Carolina, consistent with its state's constitution, create a school choice program that allows families to pay for private school tuition from a state-funded education savings account?
Oh, that sounds like it's going to be a political one.
What are you talking about? we don't do political things. We don't do that. Education law.
No, that hasn't come up before.
No.
So this will be a nice change.
Yeah, it'll be nice.
Yeah. Okay. Well, we're going to talk about school choice today, everybody. We haven't done too many of these cases, have we?
Our very first episode was a charter school case, right?
Yes. But now we're 64. This is 64. We're now 64 episodes into this gig and maybe a couple of cases that have to do with school choice. So here's another one for you. This is interesting. And this stuff is taking place all over the country, right? So very relevant. But we're going to talk about a South Carolina situation today. This is the case of Eidson versus the South Carolina Department of Education. Okay, so in 2023, South Carolina created this program to fund education savings accounts, right? Eligible families could then use those accounts to pay for qualifying educational programs or activities, which included private school tuition. But the South Carolina Constitution says that no public funds can be spent for the direct benefit of private schools.
I smell a conflict brewing.
Yeah, you do, because there is.
Because we're talking about it.
And yes, it's not so much of a conflict anymore because the South Carolina Supreme Court stepped in and said, this is what needs to happen here.
Yeah, this is no good.
No, yeah. And so we'll tell you about that in today's episode. Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, telling you the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right. Welcome back, everybody. Thank you so much for listening or watching. Just really quickly, wanted to remind everybody we've got a really exciting thing coming up in a couple of weeks, I guess. We're going to be at South by Southwest EDU recording a live episode there. So if you're in the neck of the woods of Austin, Texas, we would love to see you. Come by, say hi. If not, please, you can do your part by rating, reviewing, commenting, liking, all of that stuff, following. Yeah, so Apple, Spotify, YouTube, click that follow and like button. And we would greatly appreciate it. Okay, bell ringer, Chris. What do you have for us?
I've got an update for a case, actually a number of cases that we covered in episode 46. So that was DEI and injunction junction. We talked about, right? Yeah. We talked about a number of cases that blocked or enjoined different parts of the Trump administration's efforts to crack down on DEI programs in America's schools. So this was all coming out in around February of 2025.
Yep.
They put out these Dear Colleague letters, this other guidance that basically said, we view DEI programs as racial discrimination. That's in violation of Title VI. It was a Dear Colleague letter. A bunch of people challenged those and a handful of courts enjoined them, including one that stopped it nationwide. And when we recorded that episode, a lower court had blocked that, right? And the administration was appealing that decision. Because that's what happens. These things have to work through the process, right?
Yeah.
Well.
Oh, what happened?
In late January of 2026, the Trump administration dropped its appeal.
Oh.
which is really interesting.
That is very interesting.
So that leaves in place the lower court opinion finding that these anti-DEI efforts violated the First Amendment and federal procedural rules about creating new legal obligations. So essentially, the Trump administration forfeited and said, yeah, the lower court opinion saying we couldn't do this is in effect. So all of that like anti-DEI stuff is no longer being, I guess, championed by the Trump administration, at least those specific actions, right? So that's an important caveat there.
Yeah, no, even though it's those specific actions, I mean, it's interesting and kind of telling that they came out of the gate with this huge push about we're going to curtail DEI stuff all over the place. And they started losing tremendously in the courts. And instead of continuing to push and push and push, they just decided to back off.
Right. It's one of those situations where like you can't unring the bell, right? Where like so many schools and colleges and universities have already kind of taken actions in light of what those policies said. And, you know, a lot of states have also kind of like grabbed onto that.
That's what I was going to say. Like there's a lot of, it's not just the fact that universities and all these other, you know, institutions have said, okay, here's what's brewing coming out of the Trump administration. So we might as well kind of, you know, make some changes.
Do
that stuff.
Right, yeah.
It's much more so all these states that have sort of through their legislative process sort of enacted very similar kinds of mandates at the state level, which are still in place in many cases. Right.
Yeah. So it's really interesting that the Trump administration just dropped the appeal, and like it kind of goes to show that like while the law is working its way through the process, like practice is already kind of being changed. And so when we're talking about the law, we have to talk about not just kind of what courts do with the law, but also like how ordinary everyday people engage with the law. And so like this law like had a really massive chilling effect. And even though the Trump administration isn't pushing it anymore, or you know, the Dear Colleague letter had a massive chilling effect. Like even though the Trump administration isn't pushing it anymore, like that impact is still there. And I don't know if colleges are now like, you know, scrambling to re-implement the programs and policies, and states are going to take back those laws that they passed in light of that shift. So like, it's nice to see the Trump administration no longer pushing these appeals, but in many ways, you know, the harm's already been done.
Wow. Well, very interesting. So this isn't, I'm sure, the last we're going to be hearing about this or talking about it.
Right.
So
another one of those political issues in education law.
Yes, exactly. That little ground, what is it? The ground, that game, the whack-a-mole. Yeah. Okay, here we go. So, all right. So let's dive into this school choice case. All right. Cause this is a big issue across the country. It has been for a number of years. You know, the big push in the late 80s, and it has sort of, you know, snowballed in many ways around the country.
After COVID, we saw a surge of school choice policies around the country. Yeah,
exactly. So let's talk about one that came out of South Carolina. So today's case asks whether under South Carolina's Constitution, South Carolina can create a scholarship trust fund for students to draw on to go to private schools. And, you know, spend money on other things and whatever. But, you know, private schools is a part of that. Right?
Calling it a trust fund is an interesting choice because the connotation there is not great.
Yes.
Right?
Yeah. And we're going to talk about that in a minute. But like, you'll often hear programs like this called voucher programs, you know, school choice, that kind of stuff. The bottom line is the state makes money available to students and their families, and who then choose to spend that money on other public or private educational opportunities, right?
Yeah.
Now, like, it's important to note that this can get really messy and confusing, okay? And it's largely because, like we said, this is happening all over the country. It's happening in all these states all over the country, and every state does it a little bit differently, okay?
Right.
So it's kind of hard to keep track of, like, what is this all about? How does this work? But the bottom line is state money is being used to fund these non-public educational opportunities. Okay.
Right.
And that's essentially the bottom line. and how states do that, how states implement it, how people get access to the money. Does the money go to the people? Does the money, not go to the people, but it goes, like how they do it differs
is it one
from
check,
state
or
to
is it a
state.
bank account that you can draw money from and use it in a ton of different places? Everyone looks a little differently. And a lot of the reason for that variety is because of what's in state constitutions, like what we're going to talk about today.
Yeah. I mean, there's even instances of people being able to direct their tax dollars to specific, private organizations or whatever. Like there's just a whole ton of different things going on. So
you just got to follow the money.
Follow the money. Okay. So today's case out of South Carolina, it's a little bit different than traditional voucher programs. Okay. So typically vouchers are used to cover tuition at public or private schools. And the South Carolina policy we're talking about today creates these ESAs, the education savings accounts. Okay. And it's kind of like a middleman or a pass-through, right? So the money goes into these accounts, and then that comes out of those accounts and gets allocated to these different things.
And the big difference is parents don't have to spend them all in one place.
Yeah.
Right.
Yeah, they can just draw from that account. You want to spend $50 out of that account on a textbook, you can spend $50 out of that account. You want to spend $4,000 out of that account to cover tuition, you can do that.
Unless
the Supreme Court says you can't.
You can't.
Yeah. So no need to spend it all in one place. It's just this pot of money. Okay. So it's important to say at this point, school choice is hotly contested. It's very controversial. Right.
Yeah. We're joking about it not being a political issue, but it very much is.
It is. Yeah. Oh, it absolutely is. Okay. But it's one of those really unique issues that sit at the intersection of law and policy and politics. All that stuff kind of comes together around school choice issues, right? And supporters frame all of this as a way to give families more control over their children's education, letting students attend schools that better fit their needs, and ideally pushing this sort of entire system to improve through competition, right? This sort of capitalist kind of mindset, right?
Right.
And critics, on the other hand, of these school choice initiatives
probably see it differently.
They see it a little differently, right? And they argue that school choice pulls resources away from already underfunded public schools, okay? That weakens the democratic oversight of education because these private organizations and everything don't have as many boxes that need to be checked off. Okay. They don't have as much oversight.
Right.
And it shifts schooling away from its kind of role as this collective, shared public good. Like, we're all in this together to try to make society better.
Right. Yeah. It's essentially two conflicting views of what schools are and should be.
Yeah.
Like it's almost the distinction between like private consumer goods versus like public things that like serve children and the community, right? So like it's this whole thing of like, oh, well, choice is the most important thing versus like kind of like democratic community accountability. So like, it's a political conflict that at its core has some really like huge philosophical implications for how we think about schools.
And that's one of the reasons why it's so messy and it's so hard. Like, listen, I think there are people who generally tend to take one side or the other, as they do with most issues. But I think this is a particular issue that is a very good example of one that is messy, and you can, and if you look at all of the nuance about it, most people can probably see it from both sides, even though you might take a stance one way or the other. It's often less about like, I feel this way and the other side is dead wrong. Like it's not right. It's not as cut and dry as that. No. I don't think.
And it in many ways, school choice as a kind of policy has spanned party lines, right? Like the Obama administration, pushed charters and other kind of school choice options, right? But it's also one of those things where like you've got some really entrenched interest groups.
Yeah.
And there's some really deep conflict from, certain political actors.
Yeah.
Around those interest groups. So like there's so much to the school choice debate.
Yeah.
Beyond just kind of like the ideology of it, right? Like there's so much politics involved.
Yeah. I think it also kind of comes down to this sort of age old issue with most of these issues is like, we all want what's best for our kids. And as parents, we want what's best for our kid. And
right.
And then the question is, A, what's best? And B, at what expense? Like, am I doing what's right for my kid at the expense of somebody else's kid?
Right.
Or, and for some people, the answer is yes, and it doesn't matter, but I don't think that's the case for most people. Like most people don't want to.
Right. Which is why charter proponents would say, or school choice proponents would say that competition makes everybody better. Right.
Yeah.
But then the counter argument is like, okay, but how am I going to get better if you're taking my money?
Yeah. Well, and interestingly, if you look at the research, it's not very definitive on whether or not that happens.
Mm-hmm.
It happens in some cases,
but there's a huge turnover and charters close and private schools close and
because it doesn't happen in a lot of other cases. Right.
There's a lot of differences in quality.
Yeah. Yeah. So like, I would say it's not, when somebody says competition makes it better for everybody, the research does not back that up with a whole bunch of certainty.
Right. Which is why you see the justifications for school choice shifting. So you talked about like this all kind of came out in the 80s and 90s.
Yeah.
And it started as a way of like basically giving students in low income urban schools more opportunities.
Yeah.
And it has since evolved into now 2026 where like the primary justification for school choice is parental rights.
Yes. Listen, it ain't easy. And we're not going to solve this one here on Chalk and Gavel, episode 64.
I think we could, but if you don't want to, that's fine.
Right. But that's not what this is about. We're just going to talk to you about this case out of South Carolina. And hopefully in the process, what we do is just shed a little bit more light on the entire debate and, and how nuanced it is and how complicated it is. And if that's what we can do, then awesome. So let's try. You're ready
for it.
Okay. So we're going to go a little bit back in time. This case does not start in 2023 like you think it might.
Oh.
Yeah. This case, we're going to go back a little bit to, let's say, 1868.
Oh, okay. Yeah, no, just a short
little while
walk
ago.
Down memory
lane. So settle in, folks. We're going to take this 1 year at a time. I'm just kidding. We're not going to.
How much time you got?
No. Okay. So it's a fun little history lesson. I think this is it's important to the case, and it was included in the opinion. So they thought it was important to the case too. And it kind of, what we're going to talk about mirrors, I think, the kinds of things that happened a lot around the country.
Right.
Okay. And this is the kind of stuff that sets the stage for where we are right now. It's, you hear people talk about it all the time. Like, it's really important to know the history, right? Because it gives us a lot of context about where we are now, how we got here, what this is all about now.
What these constitutional provisions were meant to address, right? Like,
exactly.
The past is prologue. Yeah.
Yes. Okay. So 1868, that was the year that South Carolina adopted its constitutional amendment that required the state to maintain a free public school system that was open to all children in the state. Okay?
Awesome.
Yeah. Now, we've talked about these kinds of things before. We talked about it like the Oklahoma case, and we've talked about it in the charter school case, the North Carolina case. So, there's a version of that kind of language. We are required within the state constitution to provide a free public education to all the students in the state. There's some variation of that in pretty much every state constitution, right?
Yeah. All 50 states.
Yeah. So South Carolina, though, has revised their education clauses in the Constitution a number of times. And those changes are deeply embedded in the issues of race and racism.
Okay.
So let's talk about how.
Yeah.
So the first revision came in 1895. All right. And in 1895, the state adopted this amendment that required black and white children to be educated in separate facilities.
Oh, so now there's not one common system open to all. Now we've got separate, segregated school systems.
Okay, which might make you think of the Supreme Court decision, Plessy versus Ferguson, which, just to, for context, that was 1 year after.
Oh, okay.
South Carolina did this amendment. Plessy versus Ferguson kind of legitimized that idea and said, listen, as long as the facilities are equal, you can do it separately.
Recognizing, though, that they never were.
I don't think there's too much evidence that, facilities post Plessy were very equal.
Right.
But that's a conversation for another time.
It's actually interesting, like when the Legal Defense Fund and Thurgood Marshall and all those folks were pushing the courts to kind of like overturn Plessy, their strategy was essentially to enforce Plessy. They basically said like, hey, look, this stuff isn't equal. It's separate, but it's not equal.
Yeah.
And
so make it equal.
So fix it.
Yeah.
And then the turn was, oh, and by the way, separate can never be equal.
Yeah.
And it,
gotcha.
right. Like, Thurgood Marshall, obviously a hero of mine. But the strategy around all of that was really interesting. But like Thurgood Marshall was the attorney for, I think, the next case, or for the next part of this story, right? Which is the Briggs case that leads into Brown versus Board of Education.
Right. Yeah. So, Plessy was the law of the land until Brown came along, essentially, which was in the 50s, 1954. Okay. So about the Briggs case that you just mentioned, they kind of saw the writing on the wall, right? And the Briggs case challenged segregation. It was working its way through the courts. It was eventually sort of absorbed into the whole Brown thing. But the Briggs case, South Carolina's political leaders began searching for ways to unwind the state's constitutional obligation to provide free public schools. They're like, okay.
Because they saw people challenging their segregated system, right?
Yeah. And they're like, okay, well, let's try to figure out how we can weasel our way out of this obligation that we put in place in 1868. Right. And so here you're gonna love this. In 1951, I don't know if
that's true.
No, you're not gonna love it. 1951. That was the year my dad was born. In 1951.
Oh, okay.
Yeah.
Which is a great point. Like, this is not like ancient history, right? Like,
yeah. Although I like to point out to my father that he is ancient history. At this point, but he doesn't appreciate that.
Well, better be careful.
He doesn't listen to this podcast because he doesn't know what a podcast is.
Oh, well, all right.
So in 1951, South Carolina's governor was quoted as saying the following. You ready?
No.
If the court changes what is now the law of the land, okay, they're
talking about separate but equal,
but equal. If the court changes separate but equal, the governor said, quote, we will, if it is possible, live within the law, preserve the public school system, and at the same time, maintain segregation. If that is not possible, reluctantly, we will abandon the public school system.
Wow.
Unquote. So that dude said the quiet part out loud.
Right.
If you're going to make it integrate, if you're going to make us integrate, then we're just going to get rid of public schools altogether.
Right. Yeah. So they saw a choice. They're like, oh, public schools or segregation.
Yeah.
And they chose
segregation.
Oh my gosh. Okay. Yeah.
Okay.
But like, that's really important context, right? Like,
yeah.
And it kind of shows like, I guess, how deep these issues go, where like, if you are going to give up public schools, or give up on public schools, right?
Just so that you can maintain
racial segregation.
Like, yeah. So this was 1951. We're talking 75 years ago. Okay.
Which is not that long.
No, not that long. My dad would appreciate you saying that. But again, he doesn't listen.
I got you.
Thanks.
I got you, Papa Cudlets.
So guess what happened?
Brown versus Board of Education.
Brown versus Board of Education declared segregation unconstitutional. South Carolina quickly repealed its education clause and its compulsory attendance laws.
Oh.
Yeah.
So they're no longer obligated to provide a system of public schools open to all.
Yeah.
And
you don't have to go.
Kids aren't required to go to school. Okay.
Yeah. Great. Okay. So the fight to integrate South Carolina's schools took decades, as it did in many, many states. Okay. It's important to remember that, Brown was not some sort of magic, all of a sudden overnight.
No, it took decades, right?
Decades. And in the southern states often took longer.
And didn't happen on its own.
No. Many states integrated, I would say, kicking and screaming.
Yeah.
I was going to say sort of metaphorically, but I would.
I don't think it's a metaphor.
If I was a fly on the wall in some of these legislative sessions back then, I don't think it would have been metaphorically. I think there would have been a lot of kicking and screaming, actually.
Yeah. I mean, we've seen the pictures, right? Like,
exactly. Oh, yes. Okay. So anyway, took a long time. In 1963, so about 10 years after Brown, following a successful challenge to integrate Clemson University, the state passed a school choice law that provided publicly funded tuition to children who wished to attend private school.
Interesting.
Yeah, 1963.
So they're basically creating like vouchers, right? Yep. That's what that is.
Yep.
To allow, I'm assuming, affluent white families to move out of the public schools.
Yes. White flight.
Right. There's a word for it.
There is a phrase for it.
I mean, there's a whole literature on it, right?
Yeah. Private schools boomed in many locations post Brown. Okay. And it's generally for that reason. And they call it the white flight, or that's what it's referred to in this context in many places. And yeah, like if you look at a lot of private schools and when they were founded, you're probably going to see a lot of 50s and 60s and 70s.
Yeah. Okay.
Yeah. Anyway, so they passed that law in 1963, and that grant idea was specifically designed to get around the whole integration thing and maintain this kind of racially segregated system. And then a few years later, the federal courts looked at that program and said, yeah, that doesn't fly.
Yeah. Hey, by the way, you remember that time we said
a few years ago that you can't do this? You can't do it.
You can't do it this way either.
Yeah.
Right.
So that was 1968.
Okay.
And things were, slowly changing around then. The state reinstated its compulsory attendance laws, began looking at updating its constitution. In 1969, a committee recommended that South Carolina's education clause be reinstated to require a system of free public schools open to all. So all of this stuff is starting to come back, probably because they were all recognizing, we've tried and tried for the last 10, 15 years, 20 years, and we keep getting, like it ain't working.
Right. And this is also right around the time where the Civil Rights Act was passed. And now there's some massive federal pressure and federal dollars at stake too about like, hey, fix this, or you are going to be in a lot of pain.
Yeah. Money and litigation. Most likely. Right. So they also added, I think in 69, they added this new provision that prohibited public funds from being granted outright to any private school. That was an addition.
Right.
Mm-hmm. That's going to be important.
If they're attacking these segregated systems, one of the mechanisms to promote that segregation was allowing public funds to go to private schools.
Yeah.
So like you can see how that is a natural flow from like, hey, let's pull this out root and branch.
Yeah. Let's try to avoid doing the obviously illegal stuff and try to create a workaround so that we can still do what we want to do without violating the law.
Right. And they're basically saying like, let's put a constitutional amendment in place so that you can't do that anymore.
Yeah, exactly. So up until then, there had been this existing provision that said no payments to religious schools, but this addition or this change expanded that to include all private schools.
Oh, that's really interesting because like today, if it just singled out religious schools, like the Supreme Court and like our free exercise jurisprudence would have a big issue with that. That would probably be unconstitutional.
Right. Yeah.
But now it's all private schools.
Yes. Right. Again, like you just said, we've got a Supreme Court that over the last 10 years has shown particular kind of deference to when people can make the claim that they are being treated differently because, for religious purposes or because of their religion.
Right.
And
that's been elevated over Establishment Clause concerns about the government kind of being entangled with religion.
Yes.
Right.
And so I think we've talked about it on this show. Like you've got the Establishment Clause, you've got the Free Exercise Clause, those two clauses in the First Amendment that can occasionally be seen as at odds with one another. And, like Chris said, for a long time, the Establishment Clause was kind of taking precedence when it came to schools,
and making sure they stayed away from religion or endorsing religion, right? Or religious schools.
Right.
Yeah.
And recently there's been a little bit of a shift there.
A little bit. Yeah. Go listen to our episodes with Richard Katsky.
Richard Katsky, the one with Martha too. That's
another
great one. She does a great little overview of all of this stuff. All right. So anyway, all of that history is important because it's at the heart of this litigation. Okay. Because all of that was adopted in the early 70s in South Carolina. Okay. So
these two constitutional provisions.
Yes, exactly. So Article 11, Section 3 of the South Carolina Constitution requires that the General Assembly to provide for the maintenance and support of a system of free public schools open to all children in the state. Okay?
Hey, awesome.
So here we are. We're back there again. Okay. Section 4 says that no money shall be paid from public funds for the direct benefit of any religious or other private educational institution. Okay. So that kind of sums up everything that we've just talked about so far. We've now got these two clauses in the South Carolina Constitution that says you have to provide a public education for all students in the state for free, and you can't take public money and use it to benefit religious or private schools.
Okay.
Period. Now, here we are, 2023. In that year, South Carolina created this Education Scholarship Trust Fund, that we talked about before. And that is going to be held and managed by the South Carolina Department of Education. All right. And the trust fund consists of money appropriated to the department by the state, but the law says, quote, the funds and assets of the South Carolina Education Scholarship Trust Fund are not funds of the state, but are instead held in trust, unquote, for the beneficiaries of the program. So,
but they're still controlled by the state, right?
Yeah, I can see your wheels turning, sir.
Right? Like, okay.
Like, how is
this entire case hinges on, we're talking about this 2023 law, it all hinges on what is public money and what is directly benefiting private institutions. Like those two phrases that you just read from Section 4, that's the entire heart of this case. So you can already see in how they're structuring this new voucher law that they're trying to avoid. This isn't public money.
Yeah. Listen, man,
it's held in trust for private individuals.
Listen, it seems that I don't care what you call it. It seems pretty simple to me. Where's that money coming from and who's controlling it? It's the state, right? And I don't care if it walks like a duck, right?
Well, if that were the case, we wouldn't need as many lawyers, Jamie.
Right. We probably wouldn't need this podcast. So in some ways, I'm thankful for it. So, okay. So here we go. So here's how this whole program worked. So families who qualify could apply and receive access to an online account, and that allows them to authorize payments from that account to go to these, educational expenses.
Okay.
All right. Okay. So you might ask, how do I qualify?
How do you qualify?
Okay. Thank you for asking. Families would have to make less than 5 times the national poverty line, which
what is that, like 150K?
That's about it, because the national poverty line over the last few years has probably been around $30,000 or so for a family of 4. Okay. It's like,
okay.
I think it's like 15 or, 18 or something for single, but like if we're dealing with kids, it's probably going to be at least 2 in the household. So like if we're saying around a family of 4, that's $30,000. So 5 times that is $150,000. So basically it's saying if a family of 4 is making less than $150,000 roughly, then they would qualify for this voucher.
An education savings account. Yeah.
Right. So that my guess is there's probably a lot of people who qualify for that.
Right. I mean, at least there is a cap, right? You don't have these very wealthy people taking this money, and if they can spend it, if they have the money to spend themselves, I guess. Right.
And there are technically other states now who no longer have caps.
Florida,
North Carolina. Look at us. Hey.
Right.
So of course you also have to live in the state. You've got to be of school age. And we're talking about not attending the local school that you're districted for. So
sure.
So in 2024, each account was provided $6,000. So any family that qualifies has access to $6,000 if they go through the process and get approved.
Right.
Okay. Like we said, could be used for a lot of different things: tuition, books, tutoring, technology, other educational services, homeschooling, curriculum, like private schools. It could be used for a whole bunch of stuff.
Right.
Okay.
Right. But and like this is kind of like the key of the law, I'm going to get ahead of myself a little bit, but like the money came from the Treasury, went to the Department of Education. Yeah. The Department of Education opens an account that the department still manages, that parents can then tell the department to pay to other people for educational services. So like the parents and the families and the students never actually touched the money.
Right. Correct.
Right. Okay.
Yeah.
Cool.
Yeah.
Glad we're on the same page.
So if it sounds to you like this is a lot like public money going to private schools, you're not alone.
Right. Yeah.
Okay.
A lot of other people heard a duck.
Yeah. Okay. So what happened?
Well, a group of people filed a lawsuit.
Oh, I thought you were going to say something about ducks again. They just waddled into court, and
a bunch of people cried foul.
Oh.
And filed a lawsuit. All right, bring it back to dad jokes.
That was a good one.
So the South Carolina NAACP, so aligning with what we talked about with the kind of the history of race and racism, South Carolina's Education Association, so their largest teachers union, a group of parents all got together, filed this lawsuit challenging the constitutionality of the Education Scholarship Trust Fund program. And the South Carolina Supreme Court, interestingly, exercised its original jurisdiction over the case, meaning that they said, like, this is so important, we're going to take the first swing at it.
Yeah,
so there's no lower court opinion here. The plaintiffs passed go and went straight to the top.
Wow.
So let's talk about the Supreme Court's opinion.
Okay.
So the Supreme Court has to answer whether or not this Education Scholarship Trust Fund program violates Section 4, that no public funds can go for the direct benefit of private schools.
Okay.
And the state is arguing that it doesn't.
Because they're not, because it's not public money. Is that what they're saying?
Not only is it not public money, but there's no direct benefit.
How?
So let's break it down.
Okay.
So first part, is this public money? The state is basically arguing that Section 4 doesn't apply because while the money started as public funds, it lost its public character once the money went into the trust. Because according to them, the money is held in trust for the benefit of South Carolina's students. So at that point, it's the students' money and not the state's money.
Really? Is that what they're saying?
That's the entire argument.
I don't know, man.
And just like you, Jamie, the court said, no, this doesn't pass the smell test for us because, number one, this isn't a trust. Like, you didn't do all the things you need to do to create a trust.
Okay.
This looks more like a government program, which it is.
Yeah.
And two, this is my favorite part. They said, and even if we pretend this is a trust, that's not how trusts work. Under South Carolina law, and I am not a wills, trust, and estates attorney. I never took that class. So take all of this with a grain of salt. But the trustee, the person holding the property in trust for someone else, has legal title to the trust property until it's transferred under the terms of the trust. So the trustee owns the stuff, and the other person has
it's not theirs
title.
Yeah.
Right? Like they're gonna get it because that's
but
what
it
the
ain't
trust
theirs
said.
yet.
Right. So
it's still the state.
Exactly. So here that means that the state owns the money until it leaves on direct payment from the state to the educational service providers. So the court essentially says
yeah, nice try. Doesn't work on any metric.
On any metric. Right. Okay. And so there is an interesting wrinkle here though. So the state is basically saying it's no longer, it loses its public character, right? And there's a couple older South Carolina cases, and one of them is a case where the South Carolina Supreme Court upheld a college tuition loan program under a previous version of Article 4. So under that program, the state would issue bonds, people would buy the bonds, and the state would take that money and give it as scholarships or loans rather, to students who would then pay back the loan. And then the state would use that money to, pay out the bonds. And in that case, the court said that, that didn't violate the Constitution because, the court was basically holding the funds in trust. But more importantly, the funds were never public funds to begin with because it was private individuals buying bonds, and the state was just holding that money for the students. So in that situation, it wasn't coming directly from the Treasury. It was coming from people buying bonds.
Okay.
And so the state is saying essentially here, hey, this is just like that. And the court says, well,
no, it's not.
No, that people were paying for bonds. They weren't going straight from tax dollars, right?
Right.
And so this is really interesting because, Jamie, you mentioned earlier, there's a lot of different flavors of school choice, of vouchers, of education savings accounts. And one of the ones that we've kind of seen most recently is tax credit scholarship programs.
Yeah.
And so essentially under these kind of programs, private individuals donate money to a scholarship fund, and then the government gives them a 1-to-1 tax credit for every dollar that they can then count against their taxes, count against how much they owe in taxes. So if I donate $5,000 to a scholarship fund, I get a $5,000 tax credit, which means now I don't have to pay $5,000 less in taxes.
Right.
And, a lot of states have done this. And there's actually now a federal version of this that was included in Trump's One Big Beautiful Bill Act.
Yep.
And I feel ridiculous just saying that. But, some states have already tried this. A few courts have looked at it and said that it's still public funds. It still violates the state constitution. So I think Kentucky said that, where basically just because you're giving people a tax credit, that would have been state money if you hadn't given the tax credit. So it might have been a private donation, but you're still basically starving the government of money that it otherwise would be entitled to.
Yeah.
And so that makes it public money.
That's
and
interesting.
so not every state has come out that way, but it's still interesting that there's all these different mechanisms to accomplish the same goal, but they all look a little differently and they all implicate different legal issues, right?
Right.
So, that's a potential clever workaround for voucher proponents to get around this public money requirement.
Okay.
But anyway, court says, yes, this is public money, friend.
Yeah. Okay.
So what about that idea of directly benefiting? And this is a tricky one because it's an issue of line drawing, right?
Yeah.
So the the state says that, sure, yeah, like, you know, private schools are benefiting from this money because we're allowing families to choose to pay for private school tuition. And they're basically saying, like, that's not a direct benefit, that's an indirect benefit, because instead of it going straight from the state to the school, it's going from the state to the families to the school.
Yeah, I mean, I see that, but I don't see it. I see it, but I don't see it.
That's what the court says, right?
Like,
and this is a 3-2 decision. I should have said that earlier.
Oh, yeah,
like,
okay.
The majority opinion is 3 justices. The dissent
is
almost 2 justices, and they entirely disagree on this question of direct versus indirect. Like,
that's where the disagreement was. Like, it wasn't on the public money thing.
No, the dissent's like, this is public money. Like, come on, guys.
Yeah.
But no.
But they're saying that the pass-through piece, like, this is, you know, we are essentially giving this money to the family, even though they're not holding it.
Right.
They're directing how it's allocated, and so essentially, it's their money at that point. Therefore, the state isn't directly involved in. It's almost like the state saying. It's almost like they're saying, we're not deciding to send this money to that particular school.
Right.
So if it wasn't for those parents making that decision, we wouldn't do it.
Exactly. That's 100% their argument, and that's been successful.
Yeah,
in
that's
some
not
places, right?
Like I can see that argument.
Yeah. So like the Supreme Court had adopted a similar argument in Zelman versus Simon Harris, where like they basically said like, when vouchers go through families, like that kind of interrupts the state action essentially.
Right.
And so like the court here, though, the majority at least, is not convinced, because they call all of that window dressing.
Oh, interesting.
Did
they literally say that?
They literally use the phrase window dressing.
Lovely.
When you clear away the window dressing, because here the way this actually works is the money families never touch the money, right? So the payment is coming directly from the state to these private schools.
Yeah.
And so basically the court says like, choice here isn't taking away what is actually happening, which is the state paying private schools.
Yeah.
And that's a direct benefit.
So it's interesting. It makes you think, if you qualify for this $6,000 and the state just wrote you a check for $6,000, would it have gone this way? Maybe not, based on those particular rationales, right?
It very well could have come out the other way. Yeah. And that's actually one of the things that is really, really interesting about this case, is that like the court is very clear that it is applying a constitutional standard. It's not making policy decisions. It basically says like, look, this is what the text of the Constitution says. Based on that text, we can't let this happen because it violates the Constitution.
It's a combination of like closely looking at the Constitution's text, but also closely looking at the law's text, right? And
what it actually does, right?
What it actually does, right? And if the law was written just a little bit differently, even though it would have the exact same effect, it might not have been a violation.
Right. Yeah. And that's exactly what the majority says. The majority opinion says like, look, people of South Carolina, if you like this sort of program, try a different way to do it.
Yeah.
Make it different tailor it differently to abide by these provisions of our Constitution, or change the Constitution, which is something that South Carolina has done over 100 times. And like, it's doable. And so basically the South Carolina Supreme Court, or the majority at least, is kind of like, look, our hands are tied here.
Yeah.
Like, either do it right or change the Constitution.
Or deal with the consequences of doing it wrong.
Yeah. And so the court ultimately blocks, they don't torpedo the entire program. So like the
they just pull out
right. They just pull out the part that said that funds can be used to pay for tuition at private schools. And so, heeding what the Supreme Court said, since this decision came out in September of 2024, there have been a lot of proposals to either amend the Constitution or to kind of create different versions of school choice programs that may or may not fit with that prohibition on public funds directly benefiting private schools. As far as I'm aware, none of them have passed yet. But, this is obviously a very quickly evolving area of law.
Sure is. Very cool.
Interesting case.
Yeah, no, that it is an interesting case. And so, it's not, again, they're not saying what you're trying to do here by
is wrong,
directing public, somehow moving public funds in a way that allows families to use those funds for private education. They're not saying that's illegal. They're saying the way you're doing it violates how we have this stuff written in the Constitution.
Right. And that stuff in the Constitution is there for a variety of reasons. One of which is that we want to make sure that the state doesn't do any funny business to advantage some students over others.
Right.
Yeah. So like the thing that fascinates me about this case is just like how entwined all of this is. So like, we often school choice, like we talk about school choice policies in some ways as ways to improve integration between different kinds of students. Or students of different races. There's research that shows that school choice can also kind of resegregate in a lot of situations too.
Mm-hmm.
And but just looking at how the school choice debates today and the laws around school choice are like embedded in our history of, issues related to race and racism. Like, it's just like, this is such an interesting case just to kind of show how all of this stuff is connected.
Yes. Very, very deeply. And it has been for a long time. Mm-hmm. And that also means it ain't going anywhere.
Right.
It's not going anywhere. It's going to be around for a long time. And these debates are going to be hotly contested for a while. So, yeah, well, there you have it. Eidson versus South Carolina Department of Education. DOE mostly lost, but it's this round. They lost a little bit and they lost this time. But there are pathways for them to fix what was broken from a legal constitutionality standpoint, right?
Speaking of whack-a-mole.
Yeah, exactly. Maybe that should be the title of this episode. All right. Well, there you go, everybody. I hope that you enjoyed this episode of Chalk and Gavel. Again, we hope to see you, or at least we hope you listen in a few months when the South by Southwest episode comes out.
Wait, you didn't kick me the homework.
Oh, we didn't do the homework?
No.
Okay. Whoops. All right. So, Chris, what's the homework?
I said that I don't have anything.
Like, rate, review, go to chalkandgavel.com. We've got merch.
Your homework is to go find an arcade and play some whack-a-mole, because that sounds fun right now.
That's right. And then when you're done that, like, rate, review, follow, subscribe,
check out our merch, chalkandgavel.com. Go buy a coffee mug and a blanket. Stay warm.
Yeah, and support the show. Okay. That does it for this episode, everybody. We hope to see you again in 2 weeks. Have a good one.